Go.
Hello, I'm Henry Quillian. We're here at Taylor English Duma. We're continuing our Quillian's Kernels series. Today's topics will be crafting discovery for maximum effectiveness and also smart responses to discovery as well as required responses. We last time talked about preservation of evidence for trial as well as some objections that can come up during depositions for preservation of evidence. And we are going to be focusing more on written discovery today. Thank you for being here. For those that will be looking at the video out in the world, please recall that Taylor English Duma is not providing legal advice to you. This is a practical seminar for purposes of identifying issues that need to be looked at by a lawyer if you're not a lawyer, and if you are a lawyer, things you got to think about as a lawyer. Our goal generally is to take a lawsuit from beginning to end and consider things that need to be done along the way as to give maximum effectiveness to our clients, save money, avoid do-overs, and of course avoid malpractice. So, topics today are going to include drafting discovery that's appropriate for the case that you're working on, and then also responding to discovery in ways that are appropriate and necessary for the matter. And in addition to that, avoiding boneheaded responses that might end up causing you and your client great harm. As we all know, we're live here at Taylor English. Everybody will be participating in this discussion, and the goal is to get to best practices within the firm. Okay, so we've talked about lawsuits moving along. We're now at the stage where everything's been served, the answer's been filed, perhaps compulsory counterclaims, perhaps permissive counterclaims, and perhaps third-party complaints, etc. And now we're in the phase of having a limited period of time to accomplish the discovery that's necessary to handle the case properly. Now, we've got the issue of what can discovery be used for? And it seems to me like you need to look at that from two different perspectives. One is, what must it be used for? And the other one is, what can it be used for to maximize your case? Well, I have a little tool here that hopefully will be helpful in that. Generally speaking, at the early stages of a case, if you are without the knowledge that you need generally about the case, other than maybe just the necessary amounts of information in order to bring a good faith case, you have a situation where you're trying to get general light on the situation. You know, who's the witnesses, who are the witnesses that can testify before or against you? How are you going to prove up your case? How are you going to defend? What are the general contentions of the opposing party with respect to the merits of the case? As the case goes on, you want to get to the point where you're sort of focusing in on the laser aspects of the case. What specific things can I ask the other side to either make them fold, to make them evaluate their case so carefully that they realize it's got big holes in it, or alternatively, what are the specific questions I can ask to get the precise thing I need to prove my case? So we've got the general discovery, and then we have the very specific laser discovery. And you have to keep that in mind at the beginning of the case, because with respect to at least interrogatories, what do we have limitations on? The number of interrogatories, and where is that number limitation found? In the Georgia Civil Practice Act or in the Uniform Superior Court Rules?
91133.
91133, which is the rule relating to interrogatories. So in this instance, the limitation on the number of interrogatories and the statute associated with interrogatories that gives the power for a litigant in litigation to ask interrogatories. And what's the limit?
25, 50.
Georgia Civil Practice Act, it's 50, including subparts, which means, what is a subpart?
1A, 1B, 1C, etc.
Like A, B, C, D is after. So if you're asking for the the name, rank, and serial number of somebody, how many questions have you, at least in theory, asked? 3, okay. I would say that most courts give some flexibility if you're just asking general information about a person. I'm not so sure that if I was the judge and somebody asked for the name, address, phone number, and email address of a party, I would count that as multiple interrogatories, but you're at risk for doing that. If you've only got 50 interrogatories, and you know that at the end of the day you're going to be looking for a laser discovery, what do you want to do at the very beginning of the case? Ask 50 interrogatories right out of the box? Okay, no, you want to ask a lesser number so that you can ultimately have some available to ask the laser discovery. Similarly, if you have if you're representing multiple parties, do you want to ask the same thing of the opposing party on behalf of all defendants in interrogatories? All opposing parties? The answer is no. Why?
You're getting the information from one, so you don't need to duplicate it.
There you go. In interrogatories, you get what in response, in theory? What are you supposed to get in response to asking an interrogatory to an opposing party?
A written answer.
You're supposed to get a sworn answer.
Right.
And that sworn answer should be good for all the people you're representing, not just for the one that asked it, right? Request for admissions, if I'm a party and I serve request for admissions on another party, and I'm representing multiple parties, can the admissions that are obtained from one part, from the opposing party on behalf of client A be used by client B? If I'm representing clients A, B, and C, and I've got defendant D, and I, on behalf of A, ask request for admissions to D, and D responds, can client B use those responses? Well, they can use them for cross-examination, but there's a question of whether you can use them for an actual admission for purposes of winning the case on summary judgment. I see some skepticism back here, but I believe the rule addresses that. And it's particularly in the case where a party fails to respond to discovery, to a request for admissions. I think only the party that asked the request gets to take advantage of the admissions that arise out of those. So we got to figure out what we're going to ask up front, and basically, I think we've gone over this before in the earlier video about what might you serve with the complaint. With the complaint, you want to ask some basic interrogatories like who are the witnesses, who has knowledge of this circumstance, ask your basic 9/11/26 expert witness interrogatory, things you might forget to ask down the road that you know you're going to have, and then you save some. Now, if you get to the end towards the end of discovery, you've used up your interrogatories. Is there any possible way of asking another one and getting it responded to? Yeah, I see some nods. How did you do that?
File a motion with the court.
Yeah, you can ask the court, give me more interrogatories and explain why you need them. Most courts will give you a limited number of additional interrogatories if you've done that within the discovery period so that there's still sufficient time for you to serve interrogatories and have them responded to within the discovery period. All right, so asking interrogatories, what do you want to avoid? Well, let's go. What can you ask interrogatories about, and who can you ask them to? So what can you ask interrogatories about?
Facts and parties.
Okay, those would certainly be included. What is the actual definition of what can be asked about in an interrogatory?
Facts that are reasonably likely to lead to the discovery of admissible evidence.
Reasonably calculated to lead the discovery of whatever that means. It may mean likely. So the classic case is you're representing a plaintiff, you're suing a defendant for breach of contract, let's say. Can you ask the defendant about all their net worth and holdings?
No.
You can ask them, but you can't necessarily get them to answer, right? So that might be a completely wasted interrogatory. Why is that? Because in a breach of contract case, the net worth of the defendant is generally what?
Post-judgment discovery, not relevant to the issues.
It's not relevant, so if you ask the question, it's not reasonably calculated to lead to the discovery of relevant or admissible evidence, right? So, now, let's say you've got a fraud case and you can state in your complaint sufficient facts to show that the defendant actively committed fraud with scienter that resulted in damages to your client. Then can you ask for net worth information and interrogatories from the defendant and expect to get responses? The answer is yes, because if you have punitive damages, the net worth of the defendant is relevant to the punitive damages calculation. Now, some courts may require you to survive through a motion to dismiss or through some other sort of prima facie showing before you can force that discovery out of the defendant. But the point is, you need to know what ultimately is relevant and admissible evidence in your case if you get to the point of proving up the facts. And those are the ones you're supposed to ask about and expect to get answers from. Now, do you want to ask mealy-mouth, confusing interrogatories to the defendant?
No.
Or to the opposing party?
No.
No, you don't, and because if you do, what happens?
You get objections, and you don't get the information you want.
You get objections, you don't get the information you want, and you waste your interrogatory, right? And so, you need to ask interrogatories that are clear and not asking for the world, but asking for some information that can be reasonably obtained from the defendant based on what you ask. And of course, that information needs to fall within the realm of the 9/11/26 definition of what discovery is for, which is finding reasonably information that's reasonably calculated to lead to the discovery of relevant or admissible evidence. Does that mean what you ask has to be ultimately admissible in trial?
No.
No, it doesn't. The test is, if I find out this, that must mean that, and then you can go ask that, which might ultimately be admissible in trial. So, one thing to be careful of is definitions and instructions in your interrogatories. People like to put all sorts of instructions in interrogatories and in other discovery, and some of them may or may not be applicable at all to the type of discovery they're asking. For instance, in a request for production of documents, which is for what? Asking for what from the other side? Documents. All right, sharp crowd here. You can put in your instructions, please provide a list of everything you haven't provided, but that's not a request for production of documents. It's not contemplated within Rule 34 unless somebody is asking for a privilege log and the court has found that it's appropriate for a privilege log to be provided. But basically, the response to a request for production is objections and telling what is to be produced and then actually producing the documents. It's not coming up with answers based on interviews of your client other than asking them where are the documents, what documents do you have, etc. Similarly, all right, this is a question, is there any such thing as a continuing request for production of documents?
There's a requirement to supplement, but I don't know about continuing.
There's a requirement to supplement your responses to request for production if what?
You can determine they were incomplete or inaccurate at the time you made the response.
There you go. If at the time you made the response they're incomplete, then obviously you haven't done your job. You have to produce the documents you didn't produce earlier. Or if it's incorrect, like you say, we don't have any such documents, when in fact you do, then you better supplement. But if you go out as an attorney and find a document that's responsive to the request for production and it's not from your party defendant, or your client, I'm sorry, do you have to just throw it to the other side and say, we found this, we're producing it now?
No.
The answer is no. It might come up as a listing on your pretrial order, if you want to get that document into evidence, but you don't have to give it as a response to discovery. Now, how about interrogatories? Is there a duty to supplement interrogatories?
Yeah.
Yes, and that's especially true with respect to what kind of questions?
Experts.
Experts. If you just want to disclose a new expert for use at trial, not a consulting expert, but if you want to disclose it, if you want to have a new expert that's going to testify at trial, you have to answer an appropriately lodged expert interrogatory under 911 what? 26. You have to, as the responding part of those interrogatories, you have to identify that new expert appropriately, even if you've already answered the interrogatories once and you didn't have an expert at that time. Okay, what other kind of interrogatories have to be supplemented? The answers.
Witnesses?
The witnesses. If you learn additional people that have knowledge of the facts, and somebody has placed an interrogatory in your inbox asking you to identify the people that have knowledge of the facts, you have to disclose those people in the interrogatory responses. Now, what if that same interrogatory says, and tell me everything they know about this case? Do you have to answer that? Now, I see Cedric, one of our summer clerks, shaking his head no. Now, why is that?
I mean, I feel like that would be part of your job to figure that out.
It's work product, right? And you say you could have a work product objection to the tell me everything this witness you found knows request. So the point of the matter is you got to read the rule, determine what has to be supplemented if you're the responding party, and if something comes up that you realize, oops, this wasn't included in my interrogatory responses, you need to go back each time and make sure you're appropriately supplementing your interrogatory responses. Now, let's throw one out there. Focusing on responses here for the moment. Let's say you're a personal injury plaintiff, and you're suing somebody for wrecking into your car, they mashed up your car, you got personal injuries, and the defense sends an interrogatory that says, describe your damages incurred in the accident. What are your options as far as responding to that interrogatory? Just generally, what are your options in responding to interrogatories? You can object, yes.
You can answer subject to the objection.
You can answer subject to an objection, okay, what else?
Provide a reasonable response.
Or you can provide documents sometimes.
Okay, you can provide documents, we'll go into that.
You can say-
That's under 911-33C. C, right?
You can say,
Is D in federal, is it C in state?
Excuse me?
Is D in federal, is it C in state?
I believe it's C. We'll check that out, we'll read the rule.
you can say something to the effect that discovery is ongoing and you haven't fully ascertained damages, but, you know, you'll supplement at the time that they are determined, something like that.
I
Yeah.
mean, getting to, you have a duty to investigate, to try to answer. You just can't say, I don't know, therefore, you know, go on and
Okay, so you have a duty to go find an answer if it's an interrogatory, right?
say, a
All
reasonable.
right, now, let's think about among these options. If you're the personal injury plaintiff, the defendant sends you a discovery request that says, describe your damages. Do you want to object and say, objection, this interrogatory is not reasonably calculated to lead to the discovery of relevant or admissible evidence? No, why not?
Because you're saying that damages aren't relevant to your.
Yeah, which would be it could be an admission to completely undermine your case, right? So that's what I call a boneheaded response. Now, boneheads do exist out there. I can guarantee it. People will give you a stupid response like that to a question on a fact that's perfectly well drafted that they actually have the burden of proving at trial. And it's my belief that you could go stick it to them if with that exact response. If they start putting up their damages at trial, and then in the meantime, let's say they haven't given you any more information, you could cross-examine them on this. You're saying this is not reasonably calculated to lead to the discovery of relevant admissible evidence. Why are you trying to present this to the court? Never seen that done, but I think it's fair game. Now, how about discovery is going on. Let's say it's 1.99 years after the accident happened, the lawsuit gets filed, the defendant sends this interrogatory, and it's 1.99 years after the accident took place, and the plaintiff says, I'm still trying to figure out what my damages are in the case. And if they go on to say, and I will supplement them when I know what they are. Is that a very powerful response for a plaintiff trying to recover money in a personal injury case? No, terrible, terrible response. By the time the case has matured that far, they might want to put a catch-all at the very end of a long listing of actual damages they know they've incurred. But you certainly wouldn't want to be lazy and give some response like that if you want to ever get your case settled, because it's basically saying, we don't even know what our case is, we're 2 years out, we're going to fudge on the critical issue that we want you to take into account when you're paying us money. Now, what's the risk of saying, and I'll supplement the interrogatory down the road? You forget to, and then you're really in a bind when you all of a sudden try to do it. Maybe it's outside the discovery period. It's no longer, the other party no longer can cross-examine you on what your response is. Are you taking on supplementation responsibilities that are broader than required by the Civil Practice Act? Quite likely you are, because not everything has to be supplemented.
Well, I guess my point, Henry, is one, that response is routinely used. Two, there are appropriate times to use it. Now, in your hypothetical, which you didn't give me before you asked your question, that may not have been the time. But if you have a plaintiff personal injury case and you don't have the injured party has not reached their maximum medical situation, in other words, you don't know exactly how many surgeries they're going to need or what their ultimate loss of earnings might be, it may be appropriate. But you will have to produce evidence of that to get it into the trial, or you will be prohibited from introducing that evidence. So I think most plaintiffs' lawyers, if they're in that situation, they're going to remember to supplement, because if they don't, they can't introduce the evidence. But having said that, I agree with you in general, it's probably not a great response, but there are times when it's appropriate.
Oh, by the way, Greg is correct. The question that he answered, which was, what are the options that a party might pursue in response to an interrogatory? I was not in any way suggesting it was the answer to give when Greg gave we each gave options. And Greg is correct that somebody that's on their toes is definitely going to come back and supplement that interrogatory. Otherwise, they'll be in major trouble when they come to prove their evidence of trial. But my belief is that if you are the personal injury plaintiff, and unless for some reason you have to, let's say it's a defendant that's about to go out of state and you have to file the lawsuit almost immediately after the incident occurred, then you ought to give a more thorough response regarding the evidence you actually have at that time, because otherwise your whole thing is suspect. I actually had a case one time where a ship wrecked into a pier. It was some South American chartered ship ran into a pier, and all the discovery, all the depositions had to be taken the day after the ship ran into the pier, because that ship was taken off the next day and there were people from all over the world working on that ship. And so, as the party representing the property owner that was damaged, we couldn't have given a response. All we could really say, if somebody asked an interrogatory right away, all we could say is, they knocked down our pier. We don't know how much it's going to cost to fix it. So, but believe me, we developed that claim over time. Okay, so one thing is you never want to say in response to discovery that ask for questions that's exactly what you have to prove at trial, whether it be if you're the plaintiff and you have the burden of proof, or if you're a defendant and it's your primary defense. You certainly never want to object on the grounds that the answer that the interrogatory does not request information reasonably calculated to lead the discovery of relevant or admissible evidence. Now, what other sort of objections are there to discovery, such as interrogatories?
See privileged information.
So you got privilege, and what kind of privileges do you generally have?
Attorney-client,
Attorney.
accountant, in Georgia, accountant-client.
Yeah, you get, okay, everybody know about the accountant-client privilege in Georgia? And then you got work product. You got trial, which is a brand of trial preparation information. And then you have, so those are the basic privileges you need to think about. You might have some others under very specific
Have a
circumstances.
spousal
In certain circumstances, you might have spousal privileges. You know, basically,
The trial preparation protection extends, to agents and insurers and other representatives of the client, not just to attorneys. So you gotta,
right.
I've got one case right now where, a real estate agent was helping out the client in anticipation of litigation.
Okay, let me ask you this. Is the trial preparation privilege, which is filed in what rule? 9/11/26? Is it bulletproof? If somebody generates trial preparation materials, can they be certain that they never have to produce that evidence prior to trial?
No.
No. And what are the limitations on the trial preparation objection?
If the requesting party states and proves that they have, I can't remember the language, but if they have compelling need for that information and they can't otherwise get it, or something to that effect.
Yeah, so if the person who did the trial preparation is the only person that has any knowledge about this subject matter, and it just happens to be they were a party witness, and that's the only way that information can be obtained, and it's obviously a compelling need of the opposing party to have it, then you can pierce the trial preparation objection and potentially ultimately get the information.
You only can get the information that you specifically request. You can't get all the work product, right? Like if it's like a witness who they interviewed who's left town and then nobody can reach them, they can get that interview from the witness, but they can't get what else has been worked on, right?
That's right, there's no general waiver. It would be typically fought over, and the judge would craft an order requiring production of the information based on whatever was shown to the judge and the application of the rules.
I don't think a work product objection to an interrogatory is proper under any circumstance, because work product only applies to documents.
Well, it's been argued.
Well, it depends on what,
Held that, yeah.
let's say, I don't know if we can think of some examples, but certainly you don't have to disclose your theories, correct?
In an interrogatory?
Yeah, let's say the interrogatory was, tell us the case law that you contend supports your cause of action. Who's responding to the,
Well, that's not a fact,
well, it's not a fact, yes.
But I don't think the objection is work product.
Henry, if you get an
It's
interrogatory.
a technical point, but
Get an interrogatory says, identify everybody who's given you a written statement in support of your claims or defenses in an interrogatory. I object to that on work product grounds, and I've prevailed on that. But technically, what Mickey is saying is correct.
Okay, we can do a comparison on Paul's thing. We know 9/11/26 allows for discovery of statements made by the party opponent concerning the litigation, right? So I suppose you might be able to say, well, that's what the rule says you can get, so the other efforts of the attorney in going out and interviewing witnesses are not discoverable. Now, you might actually have to disclose that you took a statement, but producing the actual statement itself is a whole
I
different
think you do have to disclose from whom you've gotten statements, because otherwise, how are you gonna know who to depose?
But then
Well,
Well,
it's revealing the mental impressions of the attorney that
But-
You have to list everybody that you've taken a statement from or what their position is. And there's good federal case law that says you do not have to identify people in an interrogatory that you have gotten statements from.
Now, what if you, there's one reason for that. It could be people you got a statement from who didn't know anything. I mean, the question that should reveal those people is state all the people you have knowledge of that have information regarding the substance of the material of the case. Those do have to be disclosed. So,
I agree with that. That's different.
yeah, it's a different question.
Well, we can make this till we're blue in the face, but to me, there's a huge difference between folks who have knowledge and people from whom you've gotten statements. Because with the limitation on the number of depositions and trying to be efficient, you're obviously going to want to go out and at least think about deposing people who have actually given statements as opposed to the 3,000 people you identify who may have knowledge about the case.
Okay, well, so is that an interrogatory that we should always ask? Who has given statements regarding this case?
I do all the time.
And then, what Mickey is saying is that gives you a view into the other side's mind, which is what Paul is arguing.
You can't get a statement because that's going to reflect the thought process of the attorney
Right.
and what questions to ask. But to identify who has given a statement, I just have a hard time. There may be cases that say anything, but to me, I think that's perfectly discoverable.
So I suppose what would perhaps be a prudent thing to do, if you think you got an enforceable objection and you don't want to give up all the people you went and they just got a statement on, object and see what happens. And then evaluate it when the other side comes back and asks for a what in connection with your interrogatory responses.
Privilege law.
Well, a good faith conference regarding your failure to adequately respond to discovery. So if they never come back and ask, who are these people? Let's say the opposing party, you object and say, this is work product, trial preparation materials, I don't have to provide statements that I obtained, or a definite list of people from whom I obtained statements. If the other side never calls up or never writes you concerning your failure to respond to that interrogatory, then do you have any obligation to answer the interrogatory further? No. So you could push that issue down the road.
This may be going off track a little bit, but in your 6.4 letter, I've always taken the position, when I write a 6.4 letter, I'm giving the opposing side the legal basis for why their objection is unfounded. But I have received 6.4 letters that have absolutely no legal authority whatsoever. They're just saying, your objection's unfounded. What, are you aware of any authority that says in your 6.4 letter, you have to, in other words, it's not good faith if you don't give them the legal basis for the reason why you contend that their objection is unfounded?
All right, we've got a great question on the table for those out there in the world. What we're talking about is Uniform Superior Court Rule 6.4.
Yeah, your good faith letter that you file before it's a prerequisite to filing your motion to compel.
All right, this is a good question. Is a good faith letter a requirement before you file a motion to compel?
Well, good faith conference.
Good faith conference is what the rule says.
Right.
And
But in my good faith, let's take the same example. In my good faith conference, am I required to provide the legal basis for my contention that your objections are unfounded? Or can I simply say, I think you're unfounded, you have to defend it, and we've met, I haven't provided you any basis. Is that sufficient good faith to then get me and support me in a motion to compel?
I think it depends on the nature of the objection. And if you object to it, you're the plaintiff and you object to an interrogatory, please explain your damages.
Right.
I don't think you have to give any explanation in your letter as to why there's unfounded.
Damages, right.
Yeah, but if it's a little tougher than that, why risk that it's not in good faith? Give a citation of authority, give some explanation. I don't think there's a blanket answer to that.
And I think what I would do is agree with Mickey and agree with Michelle that, first of all, I don't think it has to be a letter. However, I think laying out in a letter before you have a conference with an opposing attorney is a very good idea so that they will know where you're coming from when you call them up and say, we're going to work through all these objections. The other thing, as Mickey was saying, is if the opposing party to whom you've asked discovery has a whole litany of objections. Looks like they just took the paralegal's handbook on objections and stuck it in response to that interrogatory, then there can't be all good faith objections, more than likely, unless you just have the worst interrogatory known to humankind. So you ought to have, the burden ought to be on the person making the objection to give some explanation as to why they're not merely delaying and deferring and harassing your client by not responding to the discovery.
And the letter would be like Exhibit A to your motion to compel.
That's right.
Yeah, the rule doesn't require the letter or legal authority.
That's right.
Technically.
Well, the rule
But-
requires a certification attached to your motion to compel that you had a good faith conference.
Yeah.
I would think a good idea would be to attach the letter to your certification, so you could show the court, in detail what you conferred with the opposing counsel about.
That's what I was gonna extend
Yeah.
to say, which is a practical matter. As a practice matter, it makes your certification a lot easier and more compelling, gives the judge buys you some good faith for the
So
judge
the
too.
question really is whether or not it's good faith if you don't cite authority and you just stand on your position without anything to back it up.
Exactly, and I'm kind of thinking more on the other side, because I always do the letter, because I think it's appropriate, and it helps in your motion to compel. I always cite the legal authority as to why I believe that their objections are unfounded. But if I'm on the other side, if somebody files a good faith letter against me, or they ask me for a conference, and they say, I don't think your objections are founded, and I say, I think they are under this authority, and they don't give me any authority, can I then refute their motion to compel and say, Judge, they didn't confer in good faith. They're now bringing up all these cases that I didn't find or whatever, and they're filing a motion to compel on basis that they never provided us in any kind of a conference. Can I use that as a defense that their conference was not in good faith because they did nothing other than said, you're wrong, provide the documents?
I think you can, and what I do in my letter, when I give authority, I always add a sentence. If you have any contrary authority,
Right.
please provide it to us, and we're glad to reconsider our position.
And I do that as well.
And if you basically reach out and invite them to show you where you're wrong, and they still just go ahead and file a motion to compel without doing that, I think you're in really good position to make exactly that argument it was not in good faith.
And I think where I would come down on that is, if your authority is good, you're in really good position.
Right.
If you give bad authority for your point, just because you gave authority doesn't mean anything if you cite a case that's inapposite to the whole issue. And then if I was the judge and I saw there was an absence of any counter authority, if you had given at least facially probative authority on the issue of why you didn't have to produce the documents, I would say, I might make you produce the documents, but I'm not going to sanction you with attorney's fees because the party that's seeking the attorney's fees didn't go through the steps. They made me, the judge, work rather than y'all just working it out, which is what the judge always wants. The judge always wants you to work it out. Now, does it always have to be legal authority, or can it just be logic? Sure. It can just be logic in your explanation to the other side of why, if you're the personal injury defense lawyer and you're calling up the plaintiff's lawyer and you say, give me a description of your damages, certainly you can say, you don't have to cite authority for that, and just say, you're a personal injury plaintiff, you're claiming your damage, we need to know what your damages are. And in a commercial case, obviously, it can be a lot more complicated as to why a specific fact, let's say something extracted from the opposing side's computer system or something, is something that needs to be known because it will tell me whether you did this, this, and this. For instance, did somebody if the contention is that somebody on the other side accessed the computer system to do this, send out an email or whatever, it might very well be relevant to know whether that person had access to the computer, or whether they had the necessary passwords. And then if they did they actually go in on the day that whatever happened was supposed to have happened, because all that would be tracked somewhere in some log in the computer. So there could be a very logical reason why the discovery needs to be responded to. Now, what if you've got a 4-year relationship and the interrogatory and the people have been going back and forth all day long, every day for 4 years, in the interrogatory says, state the date, the participants, and the times for each communication between the plaintiff and the defendant.
Okay.
What sort of interrogatory is that under the circumstances?
That's overly broad, overly burdensome.
Okay, it's unduly burdensome for sure, because it's going to be thousands and thousands of disclosed communications, which would be very difficult for people to dredge up out of their minds. But
Overly broad.
it's overly broad because it's not limited as to time or as to the issues that are specifically involved in the litigation. Likely, it's not involved in those specific issues. And let's assume, however, for the moment, that 99% of the communications happen via email, back and forth. What options would a responding person have?
There's the email.
Say you'll produce the emails in lieu of answering the interrogatory.
What criteria go into a determination whether you can just produce documents instead of answering an interrogatory?
State court rules say it has to be business records, doesn't it?
Well,
It's 33E, right?
it's 91133C.
State.
Okay. Why don't we just read it? It says option to produce business records. Very good. Although we'll find out whether business records are in fact the only kind of records that have to be produced. Because I guess business records have a definition in and of themselves under the evidence code. Where the answer to an interrogatory may be derived or ascertained from the business records of the party upon whom the interrogatory has been served, or from an examination, audit, or inspection of such business records, or from a compilation, abstract, or summary based thereon, and the burden of deriving or ascertaining the answer is substantially the same for the party serving the interrogatory as the party served. Now, what did I just read just there? If the party asking the question wouldn't be able to make heads or tails out of the business records without the interjection of somebody that has knowledge of what goes into those business records, would the burden be the same for the asking party as for the responding party?
No.
Likely it wouldn't be, but, so we've got a limitation on 91133C, production of business records instead of answering an interrogatory. But it goes on to say, it is sufficient to answer the interrogatory to specify the records from which the answer may be derived or ascertained, and to afford the party serving the interrogatory reasonable opportunity to examine, audit, or inspect such records, and to make copies, compilations, abstracts, or summaries. So, sometimes you'll get an interrogatory that looks like a complete insurmountable task. Describe every communication two parties had over a 4-year period, but one of the responses that's available is this 91133C, if you can meet those criteria. Judges may push back on you as to whether those criteria really can be satisfied under the circumstances. Has anybody got any examples of times when the judge said, we won't simply allow the production of business records? I can't think of one off the top of my head, but there certainly must exist out there. How about this one? Has anybody ever required that the records be business records under the evidence code, admissible into evidence?
Well, the fact that they're a business record doesn't mean they're admissible. Yeah, that's just step one of admissibility. But I think your question is, to at least stipulate that they're business records.
Right. I believe if they're records that are kept by the business in some form or another, then those records may possibly satisfactorily answer an interrogatory so that they can be produced, even if they're not business records, because in fact there seems to be the option of compilations and summaries that might answer the question, such as perhaps a query on a computer that in and of itself wouldn't be a business record. If there's a database of information, they say we want to know this, the query on the computer might answer the question, but it might end up being 1,000 elements of information that would be stupid to then type up in an interrogatory response. So,
Henry, you asked the question of whether that's been used. I have used a similar situation. I had in one of my MARTA cases, they produced, rather than producing the actual incident report, so it was a crime, it was a premises liability negligent security case, and rather than producing the actual reports, they provided an incident summary log, which was the result of their query into their computer database regarding these crimes. I went back and required them to actually produce all of the incident reports themselves, and then required them to acknowledge that their incident summary logs were in fact business records, because what I then used in trial was the fact that when they put in a query for rape, kidnapping, or assault, my client's incident did not show up in the incident summary logs. So when they were looking at crimes that occurred on their premises, their database was flawed because it did not pull up relevant material crimes, and they used their database as their basis for determining what kind of security should be used on the premises. So that was an area where they thought they were being, you know, a little bit sly and only producing the incident summary logs, but when you actually dig deeper and require that they provide the underlying basis, you can get into it, but then you can catch them by forcing them to admit that the summary logs are used in their everyday.
boy, that's an example of a real interplay between discovery mechanisms and evidence law. And what is implied by the fact that the discovery they produced didn't produce what it was supposed to produce. Now, in responding to a request for production of documents, let's assume that you've got a series of requests. They're narrowly tailored. They ask for documents that are under Rule 26, 911-26. They're reasonably calculated to lead to the discovery of relevant or admissible evidence. Well, let's assume that it's a huge volume of documents that are responsive. As the responding party, let's assume you make objections, but in reality, those are all documents that at the end of the day, you know that the judge will make you produce. What options do you have as far as providing the responsive documents? Do you have to go make copies all yourself and turn them over?
Make them available.
Okay, you make them available for inspection. Mr. Munger pointed out something incredibly important the other day, that getting the actual, real, original document is incredibly important sometimes. And why is that? Because the copies can be smudged so badly you can't read them, or in a business case, at least in the olden days, you might have blue ink and red ink and black ink all in the document, which might suggest that 3 people have written on it instead of just one.
And they might be two-sided.
Might be two-sided. That's a favorite example of people just copying one side of their two-sided documents. Which means, by the way, you always have to check to see the numbering on the bottom of the document, right? If it goes 1, 3, 5, 7, 9 when it's produced, then something's wrong, right?
Well, and in Paul's case, you know, he mentioned that he had a document that not all the pages were there. And the last, you know, the missing page was a key relevant page. And I've had that situation as well. I mean, I've had a case where a guy was sitting in jail for vehicular homicide, and nobody ever saw that the paramedics report identified him as the passenger instead of the driver of the car, because they missed the 3rd page. And, you know, those kinds of things, by getting the original, by insisting on the original documents that somebody else might have overlooked in the case, you know, and I think in Paul's case, it was a significant, there were some significant admissions on that missing page that you get because you're requiring.
Now the document from his own client.
Yeah, well, and this was, I mean, I got a document from the defense attorney for the guy, you know, who was in jail. I mean, his public defender didn't, you know, she's the one who gave me the document, and didn't include the part that said he was innocent,
So like, Paul's principle is when you ask your client to get you copies of all the documents, don't trust your client.
Exactly,
Yeah.
and don't trust anybody.
I don't know if we heard that. Don't necessarily trust your client to get the documents that you've been asked for. I've got an example too. We were suing a bunch of we had a client who needed to sue a bunch of insurance companies for a big environmental cleanup matter. And they were saying, we don't have the insurance policies anywhere. Well, amazingly, all it took is us flying up to Kentucky, walking through their offices, asking a bunch of questions. Lo and behold, up there on the shelf were a whole boxes full of their old insurance policies. And they had sworn they didn't have them. So sometimes you just have to get feet on the ground and go find what you're looking for, especially if it's a critical element of your case. Now, with respect to responding, if you are the responding party and there's a room full of documents and people have asked a lot of different, very pointed requests for production of documents the opposing side has, can you just open the door to the warehouse and say, there are the documents, Mr. Plaintiff, go find the ones you want?
You have to give them some direction of which documents are responsive to which requests.
Well, you don't have to do anything, right? You can just tell them, go in there and find them. But what happens if they complain or they assert that they're going to go to the court if you don't do a better job of producing your documents? Then you have to, under the rules, you're supposed to designate the documents that have to be held in what kind of way?
Ordinarily kept in business.
They have to be held in the way that they're ordinarily kept in business. In other words, you can't get a whole army of people to mix the documents up and then produce the documents. It would have to be the file cabinets in the way that the people kept them during the time those documents were kept. And you would also have to guide the people, the opposing party, to the documents that were responsive to the request for production, if you want to be in compliance with the rules. Now, I had a case, it was actually a federal court case, but I think the same thing would apply if you had a judge that ever got around to making the ruling in state or superior court, where they did they actually produced CDs with tens of thousands of documents on them. They provided no index or anything. And the federal court ordered that the opposing side that was producing the documents index the CDs and say the base number so-and-so is responsive to this one, is responsive to this request, etc. The general idea is the people that have knowledge of the documents are going to be much more readily able to narrow the set of documents that are associated with the response than the people that are coming in, they've never seen the documents before. One thing more about looking at original documents, again, it's less relevant now than it was. But if it's a lot of faxes, sometimes I've found that the orientation of the staple in the upper left-hand corner to identify which documents were attached to each other at the time a fax went out or whatever can make all the difference in the world. Things you can't pick up while you're looking at photocopied documents very often. It could be any little detail like that, or, of course, you got the situation where something Xeroxed entirely off the page, like the fax legend at the top that says when it was sent. So sometimes the devil is in the details.
Same issue, bugs the heck out of me when the other side produces documents as copies for our use and doesn't staple them as they were originally stapled. It just gives you a big stack of 500 pages with no separation between them. That's not the way we should do it, nor should the other side do it.
That gives if you got a contract that supposedly has certain attachments to it, and all you have is a cover document and then a whole bunch of papers underneath it, you don't know which ones were attached, which ones were not, then that doesn't really give the opposing side any evidence as to what the contract is supposed to be.
Similar practice point is that there's no obligation to date stamp documents, but it sure does make a lot of sense to do it yourself and then to strike a deal with the other side where they're doing it, because down the road you lose track of where it came from.
Mm-hmm.
But it also avoids you being charged with not having produced something. You know, now you can say, well, I gave you 100 documents, but if they're not marked and later on something comes up, I've had that happen to me, but they said, well, you never produce that. I bait stamp everything I turn over.
All right, so for those of you that don't know, what is a bait stamp? This is old-timey lawyer language. It's in the old day, it was an actual physical stamp, like you used to stamp a date on something, but it is a unique number identifier that is placed onto a document using some mechanism, usually identifying the party that's producing the document, and usually serially from one to whatever, so that a party can say for sure, these were documents that were in my possession, I have produced them in this litigation, and my file cabinets or whatever were the source of this document. Now, there are many electronic ways nowadays to put a number onto a document.
Also, Henry, related to that is whether or not you should bait stamp before you conduct a privilege review. Some attorneys do it one way, others do it the other. I think the best practice is to do it first.
The privilege review or the bates
The bates first. Then you identify the documents that are privileged, but they have a bates number, and then you can argue about it. But if you pull it out, you run into the risk of Paul situation where someone accuses you of hiding a document. If you don't have the bates number, then that accusation might actually stand.
That's a very fine distinction to make there, because if you bates number everything, including all your privilege documents, you almost inevitably are going to be having to do a privilege log because you'll have all these missing documents. Whereas if you just generally object on privilege ground, you produce documents that are labeled 1 through whatever and no gaps, then nothing brings to the attention of the opposing party those documents that are missing. But if you want to avoid a contention down the road that you hid something, then if you base label them first and then pull them and provide a privilege log, people can't really argue with you about whether you've disclosed the fact you had other documents. But they can argue with you whether you properly withheld on the basis of privilege, but that's a matter for determination by the court or the negotiation of the parties if somebody convinces you you're wrong. So that is something we probably ought to discuss within the firm as to whether we want to always do it this way or that way so that everybody knows what's expected of them. Of course, and that, lots of times you'll end up with so many documents and a whole bunch of them have nothing to do with the litigation whatsoever. They just happen to be stuck in there, in which case you'd have huge gaps, and then you'd have to explain to the other side why you didn't produce the documents, even though they may have been something entirely unrelated to litigation. Okay. So the general goals are to get information you're going to need to have and to get information from the other side that they're not going to want to have to give you, some of which might be information that will undermine their own case. So what we've talked about today is some of the general things you need to think about as far as responding to discovery. Earlier on, and at the very beginning of this day, we talked about how to craft discovery so that one, falls under the Rule 26, 2, has to be responded to by the other side as opposed to being so badly crafted that they can object and say, I can't understand what you're saying. And then also, trying to draft it so that there's no good objection, because then you waste your interrogatory, and certainly don't object to things that on grounds that it's not relevant to the lawsuit if it's the very thing you have to prove in the lawsuit, and avoid making other nonsensical responses that are driven more by time to do the work than they are by logic, because ultimately you want to be consistent across the board. But if you're going to either pursue this claim or assert this defense, you don't want to have your discovery responses contradict your ultimate goal of winning the case. And I think that sort of wraps it up. Next time we will continue on towards other discovery mechanisms, more details on taking up depositions. I think we started that last time. And then how you can ultimately meld discovery into motions that are favorable for your case. And come back next time for Quillian's kernels.
Thank you.